Testing A, testing B, testing 1, 2, 3. All right, welcome everyone. Today we're going to be going over records and record keeping, responsibilities, liabilities, and statutory inspection rights from American Jurisprudence. And for reference today, we'll be using Black's Law Dictionary, 9th edition. So let's get started. Okay, so we're going to look at the summary and the scope of this article. This article discusses public records, generally, including their nature, their correction and cancellation, responsibility for their removal, their destruction or falsification, responsibility. See, this is going to discuss the responsibility for removal, destruction, or responsibility for falsification, and common law, as well as statutory inspection rights, and procedures to the extent not covered by the Freedom of Information Acts or similar statutes. It also treats the recording pursuant to statutes authorizing or requiring of it, of instruments affecting title to real property, the effect of such recording, the effect of failure or delay in such recording, the right to inspect or copy such records, and liabilities for errors and neglect in recording such instruments. So we'll be getting into some of the federal aspects of this, which will include, they prohibit a variety of actions involving records. In addition, federal statutes establish the National Archives and records and govern the preparation and maintenance of government records. And treated elsewhere, which we will not be discussing, will be things like the abstracts of titles, preparation, contents of, and regulation of abstractor businesses, gas and oil interests, incorporation, filing, recording of articles, inspection of government records. This will be under Freedom of Information Acts. Investment securities under the UCC, judgments, recording, entering, and docketing, lost or destroyed public records, mandamus to enforce a right to inspect and copy public records. This is where you need to make an order, which would be under mandamus. So we have marketability of title, sufficiency of record title, mining claims, mortgage priorities, negotiable instruments. These are all handled elsewhere in other American jurisprudence, such as vendor and purchaser, mines and minerals, mortgages, bills and notes, etc. We will not be covering any of these right now. All right, let's get to it. Please hit the like if you're in here, so I know there's some people in the room. And if you have any questions, please pose your questions so we can make sure we stay on track here. So the general definition, nature, and purpose of public record. A public record is sometimes defined as a record required by law to be kept or necessary to be kept in the discharge of a duty imposed by law or directed by law to serve as a memorial and evidence of something being written, said, or done, or a written memorial made by a public officer authorized to perform that function, or a writing filed in public office, okay, that'll be a public record, a writing filed in a public office. The elements essential to constitute a public record are that it be a written memorial, that it be made by a public officer, and that the officer be authorized by law to make it. Interesting. So all records maintained by a state, county, or municipal government as evidence of the manner in which the business of that unit of government has been conducted are public records. So what it really comes down to is that public records aren't simply the written memorial, but they are evidence of something written, said, or done, simply said, or a written memorial made by a public officer, but it's still something written. So if we want to really break it down to the most basic elements from here, I can see that it's public record serves as a memorial. So the verb here, it serve as a memorial and evidence. So two things here of something written, said, or done. And the essential elements to constitute a public record are that it be a written memorial, that's one of the elements, that it be made by a public officer, second element, and the third element here, that the officer that did it be authorized by law to make it. Sounds pretty good, right? Three elements. The officer be authorized by law to make the public record. That will help constitute a public record if we meet all three of these elements. All records maintained by a state, county, or municipal government as evidence of the manner. Evidence of the manner. So this is not just a memorial, but it's evidence of something written, said, or done. It's evidence of the manner in which the business of that unit of government has been conducted. So these are public records. Is everyone still with me? If you could just let me know in the chat that I'm still coming through. I gotta check the stream. Looks like everything's going smooth here on this end. Let me know if there's any glitches or any problems with the audio. Okay, let's continue. A public record is an account of actions or events in writing or print, memorializing events or official decisions, actions, statements, or other matters of legal significance, broadly conceived. So it's a very broad range of accounts of actions. A public record embraces any document or record which may be properly kept by an officer in connection with the discharge of official duties, but is not simply any piece of paper received by a public office that might be used by that office. A document not utilized by the public office and not documenting the organization functions, policies, decisions, procedures, operations, or other activities of the public office is not a public record. So, what do we get out of this? Is that a public record is not going to be a document utilized by the office, the public office. So it's not going to be a procedure document, work instructions, decisions, policy, functions, anything of that nature. So it comes back to what's a public record. It is going to be a memorial of something written, said, or done. And it should be in compliance with the organization, functions, policies, decisions, procedures, and operations, or other activities. The evidence of those activities being done in compliance with that would be what the public record would serve to do. It serves to provide evidence that the functions and policies and decisions of the organization is being met. If a written record of the transactions of a public officer in office is a convenient and appropriate mode of discharging the duties of the office, it is not only the officer's right, but also a duty to keep that memorial, whether expressly required to do so or not. When kept, it is a public document. Did you get this? This is very important. If a written record of the transactions, what's a transaction? I see this word a lot, and in law, it may have a special definition. The only way we can know is to look in Black's Law. So let's look into Black's Law here, and we're going to look up transaction. Let's see here. Give us a moment here to pull it up. Wow, it's way down the list here. All kinds of transactions. We got to find just the general definition. Okay, here we go. Transaction. Almost there. I'm trying to find the right page. We get right to it. Bear with me. Is there anyone still here, by the way? Am I all alone in here? All right. Transaction. Here it is. Page 1663. Okay, transactional audit. Okay, here we go. Transaction. 17th century. The act or an instance of conducting business or other dealings, especially the formation, performance, or discharge of a contract. 2. Something performed or carried out, a business agreement or exchange. 3. Any activity involving two or more persons. In civil law, here's where we are. An agreement that is intended by the parties to prevent or end a dispute and in which they make reciprocal concessions. Perhaps. I think many of these could apply here. But in civil law, this is an interesting definition here. An agreement. Transaction is an agreement that is intended by the parties to prevent or end a dispute. Wow. And in which they make reciprocal concessions. So both sides have to give a little something up, and it is intended to prevent or end a dispute. So that would be a transaction too. Great. So let's move on. It's kind of nice to really focus on these definitions here. Get out of there. All right. Let's proceed. If a written record of the transactions of a public officer in the office is a convenient and appropriate mode of discharging the duties of the office, okay, so if the written record is part of the discharge of the duties of that office, is not only the officer's right, but also a duty to keep that memorial, whether expressly required to do so or not. So it's a duty, not just a right. A right meaning that they can't be compelled to destroy it either, unlawfully. But when kept, it is a public document that belongs to the office rather than the officer. The determination as to what records must be maintained by a public officer is the prerogative of the legislature. A record may be public for one purpose, but not for another. And whether it is a public record depends upon the purposes of the law to be served by so classifying it. So, to determine whether a record may be public for one purpose and not another, and whether it is a public record depends on purposes of the law to be served. So this is how we determine. It's a purpose of law to determine if a record is for public purpose. Let's proceed. Any questions or anything we need to stop on, let me know. Let's look at this observation here. One of the nice things in American jurisprudence. The immediate purpose of a public record is to disseminate information to the public, or to serve as a memorial of official transactions for public reference. So it's for public reference. So disseminate information to the public, and a memorial of official transactions for public reference. That's the immediate purpose of a public record. The purpose of a public records law is to expose government activity to public scrutiny, which is absolutely essential to the proper working of a democracy. Footnote 14. Inherent in such law is the public's right to monitor the conduct of government. The primary purpose of a recording statute is to secure certainty of title by publicity of other conveyances, particularly as to interests in real estate. So the primary purpose of a recording statute is to secure certainty of title by publicity of other conveyances, particularly as to interest in real estate. So let's look at conveyances and see what we can pull on that. The conveyance is used quite a bit. I got to get the right, get the definition here instead of it just a reference to it. Conveyance, here we go. There we go. All right. It's weird how it doesn't always pull up right. See, primary conveyance. Where did it start? Oh, there we go. Okay. Wow, it didn't even highlight it. That's strange. All right, 411. Oops. Get over here. Convey, the verb is 14th century, to transfer or deliver something, such as a right, to convey a right, or to convey a property to another, especially by deed or other writing, especially to perform an act that is intended to create one or more property interests, regardless of whether the act is actually effective to create those interests. So conveyance is the voluntary transfer of a right or of property. Interesting. So there it is. We have absolute conveyance, conditional conveyance, innocent conveyance. So qualifications not a security, primary conveyance that creates an estate, present conveyance, a conveyance made with the intent that it take effect at once rather than in the future. So we have a mean conveyance is an intermediate conveyance, one occupying an intermediate position in the chain of title between the first grantee and the present holder. Wow. So yeah, a lot of conveyances, but usually it involves property and transfer of property and recording of it as a written transfer, a record of the act. And we want to have, okay, let's get back to AmJur here. So recording statute to secure certainty of title. So that's the primary purpose, to secure certainty of title by publicity of other conveyances. So particularly as interest in real estate. So these conveyances are the transfers. So publicity of all transfers of title is done to secure the certainty of title. All right, let's continue. We missing anything here? Oh yeah, here we go. as the definition of public record under Freedom of Information or privacy statutes, see AmJur Freedom of Information Acts. As to what constitutes a public record for the purpose of state statute criminalizing the removal, destruction, or alteration of a public record. See Section 14. And let's look at footnote. Oh, here's the public record common law doctrine governing access to such records by the public. So we have that too in sections 26 and 36. And let's see here. 14 is State XREL Morgan versus Strickland, Ohio, 2009. All right, so those are the cases there that we could refer to and other references. So section 2, manner of keeping as determining public character of record. So let's see what this means. A record is public if, by law or regulation, it is filed in a public office and required to be kept there as part of the permanent records of the office. And a record is public if it is kept pursuant to the official duties of a particular officer, even if it is not specifically mandated by a statute, but simply because an item is received and kept by a public office does not transform it into a record under a public records law. The mere fact that a writing is in possession of a public officer or public agency does not make it a public record. That document is compiled or created by a public entity does not render it a public record when there is not requirement that it be compiled or created. So not all items in a personal file or other generally public record may be considered public records, since to the extent that an item does not serve to document the activities of a public office, it is not a public record and need not be disclosed. A government entity cannot conceal a public record by delegating to a private entity the public duty of keeping it. It is the nature and purpose of a record, rather than the place where it is kept, that determines its status as a public record. So, important stuff here. The clear thing to know is that what makes it a public record is not simply because it's kept in the public office, and not simply because it is made by a particular officer, right? And it even says here, it's not even if it is kept pursuant to the official duties of a public officer, even if it is not specifically mandated by statute, but simply because an item is received and kept by a public office does not transform it into a record. So if it's official duties, so it's kept in pursuant, even if not specifically mandated by a statute, but simply because it is received and kept. So, okay, so it's very difficult the way they write this, but understand it's written like this. If a record is public if it is kept pursuant to the official duties of a particular officer, even if it is not specifically mandated by a statute. So it's part of his duties, official duties, right? It will be public if it is kept pursuant to the official duties. As long as it's part of the official duties of that officer, it is a public record. Even if it's not mandated by statute, as long as it's part of the official duties of that officer. But simply because an item is received and kept by the public office does not transform it into a public record under public records law. So just because someone received a document in the public office doesn't transform it into a record. A record is going to be a memorial of an action, something written, said, or done in pursuit of the law or duties, right? Okay, let's continue. The mere fact that a writing is in the possession of a public officer or public agency does not make it a public record. That a document is compiled or created by a public entity does not render it a public record where there is not a requirement that it be compiled or created. So if they're compiling documents, taking a bunch of things, putting them together, and they're being created within the public entity, it doesn't become a public record if there's no requirement to that compilation to be created. Not all items in a personnel file or other generally public record may be considered public records, since the extent that an item does not serve to document the activities of a public office, it is a public record and need not be disclosed. So not all items in a personnel file or other generally public record. So we say generally public record, but not a public record by law. A little blurry here, but understand that not all items in a personnel file may be considered, since some do not serve to document activities of a public office. So anything that's in a personnel file that's not documenting activities of a public office is not a public record and need not be disclosed. This could fall into applications and such, right? Maybe not an application, maybe say a resume. It's not documenting activities, right? It might be used in the course of it, but it's not documenting the activities for the hiring process. A government entity cannot conceal a public record by delegating to a private entity the public duty of keeping it. Wow, so the government entity cannot conceal a public record by delegating to a private entity the public duty of keeping it. Could this be applying this private entity could be a third-party web host for online records? It is the nature and purpose of a record, rather than the place where it is kept, that determines its status as a public record. So it reiterated this. That means it's important. This is very interesting here that a government entity cannot conceal a public record by delegating to a private entity the duty of keeping it. So if a record that you need to find, a public record, is supposedly delegated to a third-party web provider, and for some reason you're not able to access it, it could be construed as concealment, which would be a violation of the public records law, it seems. And we have footnote 10 to look at this further if anyone wanted to investigate. And that's an old case, Linder versus Eckerd, Iowa, 1967. Full text in there would have the answers to that. So next we have section 3 is a filing requirements for public records. And I just want to make sure the stream's still going. Is anyone still here? It is a good question. If so, please hit the like so I know you're here. And we'll keep moving. All right. So public records are generally subject to filing requirements, as may include physical delivery and electronic filing. For this purpose, the term file refers to the tender or delivery of a document to a specified officer. So they're generally subject to filing requirements, and it may include a physical delivery and electronic filing as part of filing requirements. For this purpose, the term file refers to the tender or delivery of a document to a specified officer for permanent keeping, to an officer for permanent keeping as a notice or record in the place where official records and papers are kept, becoming part of the permanent records of the office. That's permanent. So it's distinction. Let's get this distinction down. A distinction may be drawn between the terms filing and recording, in that recording refers to the entry, indexing, or placement of information onto official record, while filing refers to the delivery of a document to the official responsible for its recording. So we have filing and recording. Recording refers to the actual entry or index or placement of information onto the record. Filing refers to the delivery of the document to the official responsible for its recording. So this official record appears to be the document that the official will be responsible for recording. So we have our footnotes here, a lot of cases, and it seems like we're really splitting hairs here. So ownership of public records as trusteeship. So public records are the people's records, and the officials in whose custody they happen to be are merely trustees for the people. Let's read this one last time. Public records are the people's records, and the officials whose custody they happen to be in are merely trustees for the people. Footnote 1, and that's 2018, State Ex Rel. Kesterson versus Kent State University. Interesting. People's records, and the officials whose custody they happen to be in are merely trustees for the people. So, notice by public records. Public record statutes and policies serve to provide notice to third persons, requiring a recordation of a document to provide constructive notice, subject to expectations for actual knowledge and compliance with recording instruments. So this is a policy serve to provide notice to third persons, requiring a recordation of a document to provide constructive notice, subject to exceptions for actual knowledge and non-compliance with recording instruments. So this sounds like third party here, third persons, requiring a record, a document to provide constructive notice. What's constructive notice? Is a good question, and I think that's a question for blacks. Let's look in here, and constructive. Okay, hang on a second. All right, here we go. Page. All right, constructive. Adjective, 17th century. Legally imputed. Existing by virtue of legal fiction, though not existing in fact. Courts usually give something a constructive effect for equitable reasons. The court held that the shift supervisor had constructive knowledge of the machine's failure, even though he did not actually know until 2 days later. So that means constructive effect for equitable reasons. Existing by virtue of legal fiction, though not existing in fact. So I guess you have to see the knowledge is a fiction. So what else we got here for constructive? So construction. Statutory construction. So we have a lot of different versions here, but let's look at this construction. Okay, I appreciate that. That there from Archangel for Truth. Just so I know there are people out there watching. All right, so did it show up there? Making sure I'm still online here. Yep, it is working. Cool. So the construction is the act of building by containing or arranging parts or elements. The thing so built. The act or process of interpreting or explaining the sense or intention of a writing. Usually a constitution, statute, or instrument, construction. right? The act of building it. The assertion of a document's meaning in accordance with judicial standards. Constructions applied to written law is the art or process of discovering and expounding the meaning and intention of the authors of the law with respect to its application to a given case, where that intention is rendered doubtful either by reason of apparently conflicting provisions or directions by reason of the fact that the given case is not explicitly provided for in the law. That's on the Handbook of Construction and Interpretation of the Laws, 1896. So that's under construction, and we're looking at constructive. So what we're seeing here is the way this is being built is that there are elements put together to build, so it's a legal fiction, right? Legally imputed. So existing by virtue of legal fiction, though not existing in fact. So I guess it's a line of thinking, like what they're saying here about the shift supervisor had constructive knowledge of the machine's failure. So you couldn't say it's a certain facts, but perhaps there could be ways you could indicate he had knowledge of it, though he did not actually know until 2 days later. So legal fiction, actual. So this looks like a very complex concept here that we can look into further at another time. Let's continue. So, public records and statutes and policies serve to provide notice to third persons, requiring recordation of a document to provide constructive notice. So, constructive, the elements being put together to build the certainty of that title, right? Requiring a recordation of a document to provide constructive notice, subject to exemptions for actual knowledge. So if there's exemptions for actual knowledge, then you don't need to worry about the constructive notice. But if there's no exemptions for actual knowledge, a constructive notice may be required, and non-compliance with the recording instruments. So another complex thing that probably involves more about recording of land deeds than anything. In mineral rights, it seems here, right? No, it looks like it's mostly land. I don't see Deutsche Bank, 2011. This is an interesting case right here. Nation Star Mortgage, 2018. Yeah, so these are some pretty interesting cases here involving title. And conclusiveness of public records. By statute, certain public records are deemed conclusive evidence, not subject to challenge after entry, or, at least, conclusive notice of what appears on the face of the record. But public records may be subject to challenge on the basis of actual knowledge. Facts of record which would prompt a reasonable person to investigate further, or sufficient other proof. The conclusive character of public records may be said to increase with age, so that after passage of a sufficient period of time, the records may become absolute and unassailable. Oh yeah. You can see how important these public records are because so much of our smoothly running society depends on it. You know, transfer of land deeds. There's all your cases right here. Okay, we're on to Section 7 is records of federal agencies in Congress. So this gets into more of the parts of the federal government with the archives and such. So we'll briefly read this. The Federal Records Act governs the creation, management, and disposal of federal records, requiring agencies to create standards and procedures in order to ensure the accurate and complete documentation of the policies and transactions of the federal government. The Administrative Procedure Act, the APA, authorizes judicial review of a claim that an agency's record-keeping policies are arbitrary and capricious and do not comport with the requirements of the FRA, the Federal Records Act. The FRA creates the National Archives and Records Administration, which is supervised by the archivist. The archivist is to provide guidance and assistance to federal agencies with respect to ensuring adequate and proper documentation of the policies and transactions of the government, and ensuring proper records disposition, the nature and disposal and keeping of the records, right? And pursuant to this authority, the archivist has promulgated regulations detailing what types of records agencies must create and maintain, as well as requirements for agency record-keeping policies. Well, that's a mouthful. So, the archivist has promulgated regulations. So, just to be fair for everyone, let's look up the big word here. Because we're going to come across this a lot. Jeez. No, here, it should be right here. Jeez. This thing's so bad at searching words. Because the way it's scanned, it didn't really get all the words into the scan. Give me just a moment here to find it manually. Which is why, again, I like the good paper hard copy of Black's. But then I can't show it to you on the screen. So this is the price we pay right here. Wow. Okay, are we there yet? Whoa, more. Jeez. All right, we'll just go from here. I can look at you guys. Okay. Promulgated. Here it is, promulgate. To declare or announce publicly, to proclaim, to put a law or decree into force or effect. 3. Of an administrative agency. So to promulgate is to carry out the formal process of rulemaking by publishing the proposed regulation, inviting public comments, and approving or rejecting the proposal. So promulgate means is a formal process of rulemaking by publishing the proposed regulation, inviting public comments, and approving or rejecting the proposal. So it's a process, a formal process, and to promulgate is to carry out this process. Promulgation, the official publication of a new law or regulation by which it is put into effect. Okay, so let's get back to AmJur here. All right, so let's read this again. The FRA, the Federal Records Act, creates the National Archives and Records Administration, which is supervised by the archivist. The archivist is to provide guidance and assistance to federal agencies, with respect to ensuring adequate and proper documentation of the policies and transactions of the government, and ensuring proper records disposition. And, pursuant to his authority, the archivist has promulgated regulations, right? Those are, again, the promulgated ones are going to be, where'd it go here? Here we go. The promulgated is the formal process for publishing, right? Which would include that getting public input, public commentary. Promulgated regulations. So those are regulations that have gone through that formal process. So the archivist has promulgated regulations. detailing what types of record agencies must create and maintain, as well as the requirements for agency record-keeping policies. All right. So now we understand that that has the promulgated regulations, meaning that these regulations have been through that process of being proposed, the public commentary, and then adopted or rejected, detailing what types of records agencies must create. There's another important word, must create and maintain, as well as requirements for agency record-keeping policy. So there's going to be requirements dictated by the Federal Records Act, which will include maintenance and requirements for record-keeping policies. So let's see what the distinction is here. The Federal Freedom of Information Act, the FOIA Act. We defined promulgate, didn't we? In case you missed it, we'll go back here. I don't know if I missed you saying that, but to promulgate, it's right there. I'd say it's to declare, announce publicly, to proclaim, but more it's promulgated regulation. So I'd say it'd be number 3, to carry out the formal process of rulemaking. So they are promulgated. These regulations, the proposed regulations, right? By publishing the proposed regulation, inviting public comments, and approving or rejecting the proposal. So that's the process of promulgation. So the promulgated regulations mean the regulation has been proposed, invited public comments, and approved or rejected. So that's promulgated. The promulgated regulations means the regulations weren't just thrown out or appointed or prescribed. They had been through this process of proposal, public commentary, and then an approval or rejection. Okay, so back to the distinction here. The Federal Freedom of Information Act, FOIA, also requires federal agencies to keep records and to allow the public access to those records. But only the FRA, not the FOIA, requires an agency to actually create records. The FOIA only addresses an agency's disclosure requirements and is not its record-keeping obligations. Do you get this? Important. The federal FOIA Act. Now we're only talking about federal aspects right now. The Federal Freedom of Information Act, because states have FOIA acts too. This one also requires, the FOIA Act also requires federal agencies to keep records and allow the public access to those records. But the FRA actually requires them to create the records. FOIA has no effect on the agency's creation of records, only disclosure requirements. None of the obligations involving the record keeping, just the disclosure. So if there's a problem with record keeping, it wouldn't fall under the FOIA Act. It would fall under the FRA, the Federal Records Act. Again, we're speaking specifically of federal FOIA right now. Okay. Yeah, you'll probably find that word promulgated also in the in other FOIA acts too, because again, it refers to the type of regulation that's not just mandated or otherwise issued by an authority. It's something that's gone through that rulemaking process of being proposed, receiving public commentary, and then either approved or rejected before it's put into regulation. So a promulgated regulation is one that's been through that process, as opposed to, I guess, other kinds of regulations. So then we have records of the United States President. This is a good place to leave off because I don't want to get too political here, because this happens to be in the news right now. So this might get into stuff where there's a lot of overlap on the internet now with all the YouTube channels. And again, I'm not here to provide any kind of legal advice or guidance or knowledge whatsoever. This is strictly for just educational purposes of reviewing and investigating American jurisprudence and how it applies to our day-to-day functions of government, the importance of common law on the way our government functions, and how we can ensure that all these rights that are being protected by the government, by American jurisprudence, common law, and other regulations in the Constitution are there for us to use, and we can only use them by going through these courts. And the way you use the courts properly for these purposes is understanding our system of American jurisprudence, which I believe is one of the best in the world and something that likes of humankind have not seen in any time of recent written history. So on that note, we could leave off on this part here, and I'll be sure to continue further on this or on to another act if we're actually at the very beginning of this. So there's some more juicy stuff in here. I'll find out where that is, and I'll skip over some of the more esoteric or the ones that don't really touch into our regular lives. And we're leaving off on records of the president. That's section 8. Section 8, and that's records. Okay, so we have that there for the notes. And if there's any other questions, we could go ahead and look deeper in here. If there's anything else that we want to address, I'd be happy to do that now. Otherwise, we'll just call this an end of the stream, and be sure that everyone that's here will subscribe, hit that bell notification so we can keep on this journey of going through American jurisprudence and learning more and more about this tremendous body of work that's been collected about our system of government, which is something that I believe is very valuable and worth keeping. On that note, we'll take off next time from the correction or change of public records, and you see there's some pretty interesting stuff in this one too. So we'll look into this, and until the next time, I want to say thank you everybody for attending, and until next time, peace out.